USCIS asked to address specialty occupation by providing either all or one of the following things. So specialty occupation is a very tricky term for NIW. Pretty much everybody who applies for H-1B, they have questions about specialty occupation. Today, I'm not going that deep into specialty occupation. I have another video. I think I have multiple videos about specialty occupation in our YouTube channel and other place. So I advise all of you to watch those videos if you have question about specialty occupation. Also, in our next Monday live, we are going to talk about the recent policy changes in H-1B. There, I will also discuss a little more about specialty occupation. But for the purpose of today's presentation, I'm not going that deep into specialty occupation. Otherwise, I'll be kind of like distracted with so many things, and it will take so long time. But specialty occupation is a really, really important topic for any H-1B discussion. I advise you to learn more about specialty occupation. So the summary of this requirement by USCIS is that USCIS want to know that the position you are offered is really, really a specialty occupation position, and their criteria to judge this requirement is they want to know the degree is normally minimum requirement and is common to the industry. Meaning, so in America, there's a lot of positions, there's a lot of jobs that do not require degree. Even like a lot of IT positions, they do not require degree, like you must have a bachelor degree or master's degree or something. Some work you can perform without any degree at all. That's why this is USCIS requirement, like we must establish that the position the company offered to you, for that position, the minimum requirement is a degree. It must be a bachelor degree. So the bachelor degree must be a minimum requirement. And also, this is a very common practice in the industry. It's not that one employer just say, hey, I'm for this position, I would like to hire someone who has a bachelor degree in, let's say, IT or English literature or law or something. The employer cannot decide it arbitrarily. It must be a normally minimum requirement and common to the industry. So this is a thing. Normally minimum requirement, also common to the industry. So this is a very tricky requirement by USCIS. So I recommend all of you to pay special attention to this thing. Also, the position is so complex or unique. It cannot be a very simple kind of position that anybody in the world can perform. That's why, H-1B is a very specific kind of visa. US government is offering you initially for 3 years and then another 3 years of extension. And there's a multiple years of extension. So US government want to know that the position was offered to you is a very complex or unique position that requires a degree. Also, employer normally requires degree or its equivalent. That's another thing. It can be a degree or a equivalent kind of experience. That is also okay. Nature of specific duties, so specialized and complex. So the job description, the duty you are going to perform under this job must be a specialized and also complex. So if we can answer all this, if we can meet all these requirements in our RFE answer, then USCIS would be very satisfied that yes, this is a specialty occupation position. So we do not need to meet all of this requirement. We need to meet at least one. But from our firm, what we recommend our clients that try your best to meet all the requirements. Try your best to meet all the requirements. So USCIS officers, they're very confident. When we answer any RFE, no matter it's a H-1B or NIW or anything, we try to make a big petition. Like usually it's like a 200, 300, 400 pages long, a giant RFE answer. So USCIS officers are very confident that they take everything seriously and they're answering all of our questions. We would like to make sure that USCIS officer is very happy and satisfied with the RFE answer. Then they will approve your petition. The next topic for the common reasons for RFE answer is wage level. Those who do not know, again, I'm not going that deep into wage level thing, but just for like a small discussion. So wage level is when in American labor statistics platform, there's a different levels of wage, like wage level 1, 2, 3, 4, 5, 6 kind of things. And wage level ones is usually the bottom level. So let's say for a position, all the job description and everything is kind of like matches with wage level 1. And in the wage level 1, the employer is required to pay you as a salary the minimum amount, the lowest amount. So let me give you an example. Let's say one company is hiring you as a entry level HR manager, right? And your job is just as a entry level H-1B executive, perform like a very initial kind of work in the HR department, and all of your job descriptions and everything matches with wage level 1. In that case, um, your employer needs to offer you the wage level 1 equivalent kind of salary. Let's say $60,000 per year for wage level 1. However, a lot of employers, when they start sponsoring your H-1B, what they will do, they would ask for all the specialized knowledge. They will say you must have a 3 years experience, you must be certified with ABC Corporation, you must have this, that. You must have knowledge about that. So they kind of try to attract very high qualified people in the field of H1B, in the field of HR. However, they do not want to pay you good salary. So their job requirement requires a lot of things from you. However, they would like to pick wage level 1 so that they can pay you less salary, the mandatory minimum kind of salary. In that case, USCIS says that no, you cannot do that. If your job description, if your requirement is this, it does not match with wage level 1. It matches with wage level 3. So you must give the person a salary of $80,000, not $60,000. So you see that the problem, wage level and the requirement must match with each other. Otherwise, USCIS will not approve this H-1B petition. So USCIS stated that in many RFE requests, USCIS stated that wage level determination for the offered position was inconsistent as the following: experience, education, special skills, and other requirements. So, so let's say for wage level 1, the minimum education requirement is a bachelor degree, but your employer said you must have a master's degree. It doesn't match. Also, let's say in the job description, in the job advertisement, the employer said you must have 3 years of experience, but for wage level 1, there is no requirement for experience. It doesn't match. Also, the special skills. So let's say your employer is saying you must have a basic knowledge about Python, Java, PMP certified, blah, blah, blah. But for wage level 1, that's not requirement. So if the offered position and wage level do not match, then USCIS is not going to approve your H-1B petition. And that's why they would like to know if the offered position and the wage level match or not. That's another very common reason for getting RFEs. And anytime any employer, another important information, when we apply for H-1B, our client is not the person who is going to get the job. Our client is the employer. So anytime any employer reach out to us, we say, hey, these are the requirements for H-1B, and they said, oh my God, I had no idea about this. I thought like I'm just going to hire someone and sponsor for H-1B. And we said, no, it's not that easy. Of course, you have to follow a lot of rules and regulations, and these are the common rules that you need to know even before you sponsor someone, right? So that's why these are very important. Let me go to the next slide. All right, another very common reasons for RFE is beneficiary is qualified enough. So that's the thing. A lot of time we see that a lot of beneficiary, those who are going to get the job, those who are going to get the H-1B visa, they are not qualified enough for the position they already applied. So for the purpose of getting H-1B approved, the beneficiary's qualification and the offered position must meet with each other, must match with each other. This is a very important thing also. So USCIS asked to establish that the beneficiary is qualified enough by proving one or all of the following. See, one or all of the following, meaning If you just meet one of this prong, that's okay. However, we from our law firm, we say our clients, try your best to meet as many as prongs you can, and also try your best to submit as much document you can, as much information you can. The more we can provide to USCIS, the better for you for your case, because in that case, USCIS officer will be very satisfied with your RFE answer or the petition. So what are those things? Foreign degree evaluation, course catalog, and detailed course description. A lot of time, a lot of H-1B beneficiaries, they were educated in a foreign country. So I strongly advise my clients who are employers, not beneficiaries, that, hey, you make sure that your person, the people you're going to hire, they must evaluate their degree, foreign degree, with WES or any similar organization. There are like a 10 or 12 organizations. They are approved for foreign degree evaluation. So please make your foreign degree evaluated. Not only just a degree, not only it will say that, yeah, his degree is equivalent to US Masters or US Bachelor. Also, we need the course catalog of the bachelor degree or master's degree the person received from foreign country. Also, detailed course description, so that USCIS know that this person is really, really qualified for this position. Also, job description and educational requirements justification. So a lot of time, as I said earlier, a lot of employer, when they advertise the position, they will ask for a lot of qualification. They will say you must be PMP certified, you must have like a very good knowledge in Java, Python, XYZ, C++, in anything. But the position is for a simple public relation job, and US is like, wait a minute, why you need someone with knowledge with Python, Java, and C++ when the position is a public relation officer position? Why you need that? So there must be a justification between job description and educational requirement or training requirement kind of things. Alignment with position responsibilities. So again, the position, the employer, what they're asking for, and also the employee, their educational other background must be aligned with the position responsibilities. As I said, if the position is simple public relation officer, he or she do not need all these things. So it must match with all the things. Also, leadership and management experience, that's also another thing. If it is a leadership position, if it's a managerial kind of position, the person must show enough leadership or management experience. So that's another thing. Like, the three things must match with each other. One, the position. Two, the requirement by the employer. And three, the education or work experience of the person who is the beneficiary, who is coming to America under H-1B visa. If these three things matches with each other, great, your petition will be approved. There will be no doubt at all. However, if it doesn't match, it has a better chance of not getting approved. That's why I advise everybody to be very careful about this thing. All right. What is the another common reason for getting RFEs? LCA does not properly correspond. So what is LCA? LCA stands for labor condition application. Again, I'm not going that detail into LCA. That's a whole new topic for discussion. I'm not going that detail. I assume you know it. If you do not know it, please Google it or go to our YouTube channel and other place to learn more about LCA. LCA stands for labor condition application for H-1B visa. So USCIS stated that the LCA does not properly correspond with the offered position described in the petition due to, number one, job description does not match with the occupation selected on the LCA. This is another very significant thing, and I sometimes I face difficulty making my clients who are employer understand that these are the very important thing, and these must match. And the thing is, in a lot of employers, they're entrepreneur, right? They're especially a lot of small business owners, they're really, really busy with a lot of things. They do not have time to pay attention to this thing, but these are very important. So I advise all the startup owners, entrepreneurs, like when you try to sponsor anybody, please try to understand this thing. Otherwise, it will be hard. It will be hard for either you or your HR person or anybody. So the job description and the LC application must match with each other. That's another common requirement by USCIS. The determined wage was not as higher as the job opportunity was a combination of two O-net occupations. These O-net occupations, I'm not going that detail here yet now, because that's another discussion. But O-net is a is a website where there's a lot of occupations, their requirements, their wage, and everything. So those who do not know O-net occupations, please Google it. You will get a website. There's a lot of job titles and their required experiences and education, and proposed like kind of like a salary. You have a better understanding. So but the bottom line for today's discussion is the determined wage must match with O-net occupations classification. And sometimes some employers, they kind of like a combine two or three positions from O-net, and they kind of make it like a combined thing. It is okay, you can definitely do that, but the thing is your offered wage must match these combined positions. Otherwise, like if you match like wage level 1, 2, and 3, make a combine and then offer like a wage level 1 salary, that's not going to survive in USCIS RFEs and other application. Another thing is recently USCIS officers and field officers, they will actually visit your office, visit your firm, visit your company, and see whether you really need this person, this kind of experience, this kind of education. So they would like to make sure that you are not lying for application. All right, this is our last common topic for RFEs. And so recently we saw that in last 2 or 3 months, USCIS requesting biometric in certain H-1B visa cases that cite that potentially adverse information about the beneficiary. So this is kind of very scary, and I totally understand. And the problem is USCIS did not publish any detailed guideline about what is a potentially adverse information. It's very difficult because a lot of international students, most of them, they do not have anything bad in their profile. They're very clean. However, some of them, they have some domestic violence issues, some DUI and other things. So the problem is USCIS will not specifically mention what kind of adverse information they have about this person. So a lot of employers, like petitioner, they're kind of scared, and of course they will be scared to hire this person if USCIS has any kind of adverse information about the person to them. So some employer, they will send say email and say, hey, can you try to find what kind of adverse information USCIS may have about the person, because I really don't want to hire this person if the person has a big criminal record, and then down the line I'll be in danger. And it's difficult. I mean, there are multiple ways to get information. One of those is like applying for FOIA. Again, I'm not going that detail into FOIA today, but I'm just saying this is a very uncomfortable kind of situation for both employer and employees. And USCIS is until today did not kind of disclose anything. There's a lot of conspiracy theories. I'm not going that detail into conspiracy theories, but again, this is another very common reasons for RFEs nowadays. That was our short presentation today. I'm going back to Shudiksha for if there's any questions from anybody. Shudiksha, you there?
Yes. Sorry, there was a little technical issue. So thank you so much, Mr. Mahajan, for that really informative and timely presentation. Now, before we dive into today's question and answer session, we'll take a short break. Please stay with us. We'll be back in just over a minute.
At Raju Law, we don't just provide legal services. We provide a pathway to your American dream. With offices in New York, Los Angeles, Maryland, Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every step. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Rajulo, we believe in affordable, transparent pricing without compromising on service excellence. Rajulo, where your American dream meets expert legal support. Contact us today.
Welcome back, everyone. It's time for our question and answer session. There are some questions. Let's welcome Mr. Raju Mahajan.
Yeah,
Okay,
Diksha.
welcome back, sir. Let's go through some questions. There are some questions. So the first question is, can my company sponsor me for an H-1B if it doesn't have a proven track record of sponsoring H-1B candidates?
Yeah, of course. Even a very new company, very new startup, if they can show that they are capable of paying you the required salary, they can sponsor you. They do not need to establish any proven record of history of H-1B sponsorship. Even a new company can sponsor you. So there's no problem with that.
Okay, the next question is, what if my degree is from a foreign country? Does that automatically make me ineligible?
Not at all. I just explained that those who have a foreign degree, it is highly recommended to evaluate your degree with the Education Evaluation Service. There's a one very famous one. It's called WES. Also, there are multiple other companies. So you just Google it. Who are authorized for education evaluation? Anybody who is authorized to evaluate your degree, you can do that. But yeah, people with a foreign degree, foreign experience, they apply for H-1B a lot. There's no problem. Every year thousands and thousands of people coming to America under H-1B visa with a foreign degree, so you do not have to worry about with your foreign degree.
Okay, that was a good one. So the third question is, can I work for multiple employers on an H-1B visa?
Theoretically, yes, even though it's not a very common thing, but some people they do. The thing is called concurrent H-1B. So let's say you are employed by ABC Corporation under a H-1B visa, and then you decided that I need a second job for some reason. Let's say you need some more money, so you can definitely get a second job with XYZ Corporation. That would be your concurrent H-1B. Also, a lot of people they do multiple jobs for job securities. Let's say, for example, if you lose your job under ABC Corporation, then you already have a second job, and you can easily make your second job as your primary job under H-1B. That's the easy process. Also, even though you do not get fired or anything, having a second job will always help you in case if you decide to quit your job and or you lose your job. So concurrent H-1B is handy. However, you have to keep working for two jobs. But short answer to your question, yes, you can work for two companies simultaneously under H-1B visa.
Okay, moving on to next. What happens if my H-1B petition gets rejected?
Get selected.
Rejected.
Rejected. Okay, okay. Well, if your H-1B petition is rejected, then you do not have H-1B visa. Then you'll stay in your current status. So if you live in America under OPT or CPT or other kind of visa, then you will remain in that visa. And when that visa will expire, then you have to think about something else. Your H-1B is gone. And if you are living in a foreign country, applying for H-1B from a foreign country, and if your petition is rejected, then you don't have anything. Bottom line, if your H-1B is rejected, then your H-1B is gone. You do not have anything else.
Okay, so the next question is, can I switch employers easily while on an H-1B visa?
It depends. If you can find a job easily, then yes, you can switch from one company to another company very easily. There is a 60 days grace period. You have to switch from one company to another company within 60 days. However, if you cannot find a job easily, that it will be tough to transfer. The bottom line, it depends on if you can find a job easily or not.
Okay, moving on to next question. What if my H-1B petition is in progress? Can I travel abroad?
Theoretically, you can, but I highly recommend not to travel if your H-1B application is in progress, because now, especially in this current uncertain time, lot of time USS officers or airport immigration officers, they're very serious about many things. They're unnecessarily careful. So I highly advise not to travel when your H-1B application is in progress. However, theoretically, you can definitely do that.
Okay. So can I apply for a green card while on an H-1B visa?
Yes, of course. And most of the people who are in H-1B, they definitely apply for green card. However, I must mention here that H-1B by itself will not give you any green card. A lot of people, they have like a kind of like misconception. I hear this all the time. They think, hey, I'm in a student visa, from here I'm going to OPT, then from OPT to H-1B, then going to green card, which is a very logical kind of progress. And this happens a lot, but it doesn't mean that OPT will automatically give you H-1B and H-1B will automatically give you green card. For each step, you have to apply separately, meeting all the requirements, and then you get the benefit. It's not a automatic progress from one to another. But yes, you can apply.
Okay, thank you so much. So the next question is, if I switch jobs, will I need to reapply for a new H-1B, or can my existing H-1B be transferred?
In most cases, it will be transferred. Your new company must transfer your H-1B from the previous company to the new company. So remember one thing, your H-1B is under a company. It does not exist independently. It must always be under a company. So if you are employed by ABC Corporation and later you got employed by XYZ Corporation, then the XYZ Corporation must transfer H-1B from ABC to them. Theoretically, it is, you can do that, but you cannot independently stay under H-1B by yourself. I mean, theoretically, that's also possible, but it's a different discussion. Yeah.
Okay. So this is the second last question. Can I start working for a new employer as soon as the H-1B transfer is filed?
In general, yes. There are always some special circumstances, but in general, yes. As soon as they apply for transfer, you can start working.
Okay. So I see this is the last question. Is there any way to get an H-1B visa if I do not have a sponsor?
In general, no. Most of the H-1B jobs are always under a corporation. However, you can start your own corporation. That's another thing, especially those who are in modeling industry and even IT and other thing. A lot of people, they start their own company. So you started a startup, and your startup is going to sponsor you. So technically, you are by yourself, but you're always under a corporation, and you own the corporation. And this is I would not say very common, but it happens every year.
Okay. Thank you so much. That wraps up our question and answer session. Mr. Mahajan, thank you so much once again for your time and for addressing all the questions so thoroughly.
Thank you very much, Shudiksha, and I thanks all of our audiences and viewers today. And you know that every Monday we talk about different topics. Come join with us next Monday.
Okay, thank you so much.
Thank you.
To our amazing audience, thank you so much for joining us today. We hope you found today's session helpful and also very insightful. Do not forget, Immigration for All goes live every Monday at 11 a.m. EST, 9 p.m. Bangladesh time, and Nepal Standard Time at 4:45 p.m. That's all for today's session. Thank you again for joining with us. Stay right there as we wrap up. We'll leave you with the latest immigration news updates. Until next time, take care and see you next week on Immigration for All.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 3 latest developments in the immigration arena. Let's start with the headlines. Romania removed from U.S. visa waiver program by DHS. Department of State released its visa bulletin for June 2025. USCIS data shows surge in EB1 petitions. Let's get into details. The Department of Homeland Security recently announced that Romanian citizens will once again need a visa to travel to the United States, reversing a January 2025 decision by the Biden administration that granted Romania entry into the visa waiver program. The move comes at a time when the Trump administration is rapidly reshaping U.S. immigration policy through executive actions, prioritizing stricter enforcement and increased scrutiny of legal immigration pathways. Next up, the U.S. Department of State released its visa bulletin for June 2025. This month, family-based applicants must use the dates for filing, which is available on the State Department's website, while employment-based applicants must use the final action dates. This is also available on the department's website. Finally, U.S. Citizenship and Immigration Services has released data for the first quarter of fiscal year 2025, providing a detailed look at how immigration patterns are shifting in response to global migration pressures, changes in U.S. processing capacity, and rising humanitarian demand. USCIS received 7,338 EB-1A petitions in quarter 1 fiscal year 2025, up from 4,704 the previous quarter, a 56% increase. This marks one of the largest quarter-over-quarter spikes in recent years for this subcategory.